Today we will do legal dictation exercise number 99. You can get the PDF from description box. So ready? Start. Aggrieved by and dissatisfied therewith, the appellant filed an intra-court appeal being special appeal number 103 of 2004, which was disposed of by a division bench of the High Court, giving liberty to the appellant to make a representation to the concerned authority within 10 days, with a direction to the authority to dispose of the same within 3 months thereafter. Before adverting to the rival contention raised by the parties, we may notice that according to the appellant, even today there exist two vacancies. The purported chart prepared by the appellant and the record placed before us show some discrepancy. At this stage, it is not possible for us to go into the details thereof, particularly when the candidate already appointed are not parties before us. The select list was prepared in the year 1998. In our opinion, it would be difficult to issue any direction for appointment of the appellant herein at this stage. Select list was prepared keeping in view the rule as they existed. The said rule might have been declared ultra vires, but as indicated herein before, in this court, in exercise of its jurisdiction under Article 142 of the Constitution of India, it is fit to give a prospective effect thereto. It did not inter alia for the purpose of protecting the service of those teachers who had already been appointed and had been in a service for a few years. Out of 10 posts, 8 teachers were appointed on or before 18th November 1999, which was the cut-off date. The question as to whether the fresh appointees who were having regard to the said modification require to be appointed on the premise that they are placed higher in the select list than the appellant or not, in our opinion, cannot be gone into by us for the first time, since such a contention had never been raised before the High Court. The entire record of the matter, furthermore, are not before us. It is stated that 2 appointments were made in the year 2003, one against OBC quota and another against general quota. It is not possible for us to go into the question as to whether the entire quota for appointment in the category of OBC was filled up in the year 1998-99 itself, and thus appointment made against the vacant post from the said quota is illegal or not. The concerned respondent are not parties before us. We have not been informed as to whether any other person has been left out from the original merit list. Furthermore, the select list would ordinarily remain valid for 1 year. We fail to understand on what basis appointments were made in 2003 or subsequently, whether the validity of the said select list was extended or not is not known. Extension of select list must be done in accordance with law, apart from a bold statement made in the list of date that the validity of the said select list had been extended. No document in support thereof has been placed before us. Thank you. Please subscribe my channel Steno Star.